Hello friends, in this video I am going to discuss Foreign Marriage Act 1969. The first time Foreign Marriage Act was implemented in 1903 during the British rule and was in practice till 1969. But in 1969 this act was revised and amended and Foreign Marriage Act executed by the Government of India to regulate certain marriages that not come under the purview of any existing marriage law in India. However, before discussing the provisions of Foreign Marriage Act 1969, let's understand first what is all about Foreign Marriage Act 1969. There are certain marriages, especially which are not solemnized in India, do not fall under any marriage law. Therefore, to preserve and validate such marriages, Foreign Marriage Act enacted in 1969. Now the question is, what are conditions of marriage under the Foreign Marriage Act 1969? As defined in Section 4 of this Act, a marriage between parties, one of whom at least is a citizen of India, may be solemnized under this Act by or before a marriage officer in a foreign country, if at the time of the marriage the following conditions are fulfilled, namely, neither party has a spouse living, neither party is an idiot or a lunatic, the bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of the marriage, and the parties are not within the degrees of prohibited relationship. Further, Section 11 of this Act states that the marriage officer may, for reasons to be recorded in writing, refuse to solemnize a marriage under this Act if the intended marriage is prohibited by any law in force in the foreign country where it is to be solemnized. Next, the marriage officer may, for reasons to be recorded in writing, refuse to solemnize a marriage under this Act on the ground that, in his opinion, the solemnization of the marriage would be inconsistent with international law or the Committee of Nations. It means against the interests of the respective country or can harm the friendly relation of both the countries, that is India and where the marriage is taking place. But the point should be noted as mentioned in Section 11.3 of this Act, where a marriage officer refuses to solemnize a marriage. Under this section, any party to the intended marriage may appeal to the central government in the prescribed manner within a period of 30 days. Remember, it is 30 days from the date of such refusal, and the marriage officer shall act in conformity with the decision of the central government on such appeal. Further, Section 13 of this Act states that a marriage by or before a marriage officer under this Act shall be solemnized at the official house of the marriage officer with open doors between the prescribed hours in the presence of at least 3 witnesses. Now, the most important question is such foreign marriage valid in India? As defined in Section 15 of this Act, subject to the other provisions contained in this Act, a marriage solemnized in the manner provided in this Act shall be good and valid in Indian law. Now, the question is, what are the salient features of Foreign Marriage Act? Following are the salient features of Foreign Marriage Act. The Foreign Marriage Act of 1969 facilitates solemnization of civil marriages by Indian citizens outside the country India with another citizen or with a foreigner This act doesn't concern with the religion of the parties to an intended marriage. This act facilitates person to marry either within his or her own religion community or in a different religion community. Next, in order to implement such provisions purposefully, the central government has designated marriage officers in all its diplomatic missions abroad. The marriage may be solemnized in any form which the parties may choose to adopt. And a marriage which is already solemnized in a foreign country under any other law, including the local law of that country, can be registered under the Foreign Marriage Act 1969, provided if it fulfills the certain conditions mentioned in this act. So, this is all about the Foreign Marriage Act 1969.